phone number one.
First,
Yes. Token credit.
thank you for the tips.
Keep the test. Keep the test.
Keep testing.
Yes, yes.
I think we can do a quick one. Let's make it.
Testing.
That's gonna be really nice. Hola.
Testing.
Ah, I like it. It says hola. Hola. Kick it off, Tanya.
Okay, for taking pictures.
Yeah, the minority is too much for
Let's go inside.
Hey, guys. I'm going to sing. I will say one.
If I need to speak, I can. Maybe. We have a lot of people. Maybe these are panel.
Yeah. Okay, let's start.
So, we already I don't see any reason why we start with some introductions. My name is Liability. I'm going to be moderator of this panel, where I have the pleasure to host dear colleagues and we are going to discuss about DAOs and regulation. So we have today Vienna Blockchain. We have and we also have So I will give you each one the floor to introduce themselves and start with a small question about the most interesting project you worked on DAOs recently. So I'll start with Maya.
Hi everyone. Well, my name was Marissa. My name is Blockchain. My background is in law, and both that. I think that you can hear me. I speak like really loud. So yes, so my background is in law, and the founder and CEO of Black Fogel. Black Fogel is a network of consultants that work with the new technologies, like we do a lot of blockchain, but we are also working with AI and different types of like applications of intersection of like different technologies, mostly on real world applications, but we also do a lot of things with the financial sector. When it comes to that, I think that the most interesting part that I did, the project was a research project that we did with a project called Blockstones, which was part of a European grant. And what we did was a research study on 13 frameworks in 10 jurisdictions, if my memory doesn't fail, because that was a year ago. And we were looking how DAOs were regulated, like which type of legal buffers they were used. And then what we did was a comparison to what actually was happening in the industry. We interviewed a couple of like DAOs to just like see which buffers they were picking, if there was no legal buffer, how they were protecting members or liability perspective. And then with all of that research, I did like some recommendations to the European Commission on how to approach DAOs, and I guess we are going to talk a little bit more about that later. Okay. Might some more.
Both?
Yeah.
Okay. Okay.
Then I'll quickly introduce myself by being as slow as possible. So I'm a lawyer, specializing in DeFi, sequences, governance, DAOs, this all the portfolio process. I'm based in Switzerland, but obviously DAOs from Central, so a very global approach. The most interesting thing that I awesome, I don't need to So the most interesting project, it's not actually a project, it's just realizing how little self-awareness some DAOs have. And this is something I realized thanks to Mika with the white paper, because once you have a token, you need to describe the functionalities, and you end up describing the governance function. And then the question arises, what can people vote on? And sometimes the answer is like, oh, a bit of everything, but then actually not that, it depends, and in some cases you just realize that no one has a clue what's happening. But still, it was very short.
I think they don't have batteries.
Okay. But that was basically just probably realizing that although everyone mentions DAOs, everyone identify as an organization, but there's a very big lack of self-awareness of what actually is happening in that organization. So you have like those two. So we're some context. Like on one side, something that's like over-engineered, they know everything exactly, it's like complicated to understand. Or on the contrary, it's really different. Maybe it's just experience I had and like as a chaser, but it's quite interesting to see the practice how it goes.
Okay, thank you. And interesting, relevant to the DAO.
Thank you. I first of all, I have to adjust the tone of my voice. I mean, I can speak loud. I'm Italian, yes, but I'm also jet lagged. But then I also realized that we may or may not have an age gap. Because when you said, I don't want to shout, it reminded me that there was a song in the 80s, the golden 80s, called Shout. I don't know who remembers Shout. But yeah, my generation is coming. The Tears for Fears, Shout, Let It All Out. Yes. So let's, thank you. So we are having our little moment here. We can sing. We should sing maybe at the end if we deserve it. It was good. Shout was good. So I mean, that's it. So my name is Luca Castellani. I'm Italian. I work here across the subway at the United Nations, UNCITRAL United Nations Commission on International Trade Law. I've been there for a bit. I worked first on uniform contract law and then on we call it traditionally electronic commerce law, and now we call it maybe digital trade law. But fast forward, because we cannot go through all the success over the decades. UNCITRAL now in July considered a guide on the legal aspects of the use of DLT in trade. Because we are lawyers, we are difficult with words, so we don't call it blockchain, we call it DLT. And this guide, which is a work of the Secretariat and not of the Commission, but first of all, it's already available in the draft form, but quite advanced in the 6 official languages of the United Nations, on the UNCITRAL website, and secondly, it was approved for publication, so we are now finalizing. And that guide deals with the two aspects, procuring DLT and then delivery services with DLT. So the user or the person interested in that guide is a business person or also a non-profit person who either wants to know how and what, because we of course we don't favor the use of DLT, but we say if there is a business decision to use DLT, then these things should be taken into consideration. And then on the other side, once there is a decision to use DLT, because there is an advantage, these things should be taken into consideration. Now, when we were putting that together, of course, DAOs came up. And there I have to say, I believe being in charge of coordinating this project, I believe that the DAOs could provide an opportunity, because there is currently a discussion on how to deal with DAOs from the legal perspective. And I would like, first of all, to clarify, UNCITRAL does not deal with regulation. So this discussion, this panel, I hope at least, is about how to promote the use of DAOs by giving some legal certainty and predictability on certain aspects of its use. It's not about, we always say this is the enabling legal framework, and it's not about regulation. It's not about setting conditions or putting limits on what can be done. It's about removing obstacles to the use of DAOs. And so in the preliminary survey, we saw different suggestions. I'm sure many of those suggestions came from the other distinguished panelists on how to use the existing legal structures. Now, you already said legal wrap. It's a beautiful word. It just doesn't make sense to a traditional lawyer. So we have to bring that concept into, and then of course there are other considerations like to what extent what we call party autonomy, that is to say the ability of the parties to contract certain aspects may or may not apply. But the bottom line is it useful to think about these issues? And my answer is usually it is useful because it increases the predictability and the buy-in of the traditional users. And then if we decide that this is useful, then the second step is how to go at it. And so, well, someone thinks it's not useful. So we had a sign that it's not useful. So if we decide to go at it, but UNCITRAL works, for instance, by preparing model legislation. But it doesn't have to be immediately something like that. It can be something less, like, study or, options. And we have been doing things in a certain way because we are, of course, a commission of the United Nations General Assembly. So we have rules and procedures and we have formal state membership. But before we get there, we can immensely benefit from expert input and from practical input and also from cooperation with other entities, including formal entities that are interested in this. So basically I'm here to gather ideas on how we can continue this, bearing in mind that we have already some reference points like the Koala model law. So it's not totally, blank sheet. But then, of course, there is the possibility to build.
Thank you very much, Luca. And this leads me to my next question in order to frame a little bit the discussion here. What do you think is the biggest issue within the DAO ecosystem nowadays? You gave us some food for thought, but I would like to hear maybe first from Anne.
I think it's a continuation of the example I gave. It's like a self-worth, but also clarity and transparency on what there is, because data is now used with everywhere. There was also a trend that was created by some regulatory attempts at saying what is decentralized or not. Everyone is a DAO, and then they're not regulated. So we basically put this more as a marketing label on some organizations and we ended up having some founders just mentioning, oh, let's have a governance token. What can they vote on? We'll figure it out. How much of a DAO is that, right? So it's just being transparent, and I think Diana also liked this idea of having a white paper or whatever we can call it, where we don't only explain the project, we don't only explain the token, but also the organization that's supposed to govern that project. If there is one, if it's not just a centralized entity and you want to have a community, what is it in charge of? Or is there like a team? Are there committees? Is there someone directing in the tool? What is the liability? And this is like next step, but let's just start with the basics of what is this thing? What is this monster we're trying to apprehend? And everyone has different disclosures currently. We have documentations, like Git-group documentation. Some people have charters and can vote on, others don't have it. Some people use snapshot, others use something else. And when you ask the DAO, okay, is it on-chain governance or not? Who can vote? What is the system? What was the latest vote? Like, we lack a lot of information presented to us in a harmonized manner, and it's not normal. When I join any association, I can check the charter, I can check how to become a member, who is eligible, how many members they are. Like, how come that here we're joining DAOs potentially, without even knowing what we're joining? Maybe the DAO is just, I found one example in a register of a DAO where there was one member officially to start with. And they were like, no eligibility criteria. But I think it was probably a joke, someone would just tested the system of using a wrapper that's meant for DAOs, using the DAO name in the name. But when you read the documents, probably it wasn't even meant to be a DAO, and I researched there wasn't no website for the project. So maybe it was just a test. But it shows how this word is used in a lot of contexts, and we don't necessarily know what was behind it. We all have probably here some sort of understanding of DAOs because we work in the space, we've seen some good examples, but a random person will not know. So if we want to push the debate forward, we need to be more transparent about what are the good examples and just ask the right questions. Again, let's go back to the Mika white paper. We may love it or hate it, there's a lot of bad stuff about it, it's a lot of compliance costs and burdens, but at least it forces people to ask the right questions. And when we realize that sometimes projects don't even know what their financials are, well, it's the same with DAOs. Like, if you don't even know what happens in the organization, well, maybe ask the question first before trying to grow and this kind of thing. So, transparency and clarity.
Thank you. Mariana.
I will echo that, but like I think that it's not only what it is about what we want to do with it, which also goes a little bit on what you were saying. And the predictability, I think that is like one of the key things here, because I don't think that there is. I mean, first of all, this is the fall of the industry for keep coming with like this like hot words like smart contracts and self-sovereign identity, that the only thing that do is like confuse people. Like a smart contract is not a contract from a legal perspective, and sovereignty is something that comes to the States, so of course they hate the fact that we talk about sovereign identity. So DAOs is the other thing. DAO with one person, that's absolutely ridiculous, because it just like means the second part of the DAO, like what is the organization if you're just one person, and how is that even like autonomous or decentralized? It's absolutely ridiculous. And I think that this is the fall of the industry, to always try to use like these fancy words to attract new users, and at the end, whatever we do is just create confusion. On the what, I think that is the actual question, because I never said that we should or not implement legal wrappers without not knowing what they want to do with the DAO, right? And like when you talk about white paper, like I used to call it like bylaws, but like that's also too traditional. White paper now is hated because of Mika, so I will come with a new word following like the legacy of the industry, also like that, and confuse people. But basically what we need to understand is like what is it that these people that is coming together and create a community or a collective or whatever it is want to do. And depending where those actions fit, they will be a legal entity or not. If it's a community and then they just want to do education things, what the heck are they looking into legal wrappers, right? If they actually want to engage in finance, if they actually want to do commercial activities, then they will need one of the traditional legal wrappers. Like, what are we going to reinvent the wheel? Foundations, associations, cooperative, LLAs, like whatever you want, right? I think what makes unique the DAO is the governance part. And the governance part can be integrated into any of those legal forms that will respond more to the activity than anything else, right? And that is something that like I've been discussing before, is that like you need to not only understand what is it that you want to do, but like how you will do that. And that comes on like who is going to be part of the DAO. Is every token holder considered a member of the DAO? That will be absolutely ridiculous, because that will mean that the fact that I hold a token will make me liable somehow. And then what are the levels of liability? If I vote against a decision, will that make me equally liable as the ones that voted positive for a decision that was implemented in cost damage? You will need to define all of those things. So you need different roles, like also like those roles that will represent the DAO to the outside world, like in case that something goes wrong, or who is going to be the one that goes and talks to the authorities? Who is the one that is going to be responsible? So I think that all of these things are what it needs to be defined in a white paper, in a bylaws, a document, whatever you want. And this is the things that we should be looking at it. Because if we try to regulate DAOs as a whole, it's like us trying to regulate like NFTs as a whole. Like every NFT can do different things. Some are collectibles, some are actually like just a certificate on the blockchain, right? So it's ridiculous to try put everyone on the same box and then I pretend that we can regulate all of them the same, because they're like absolutely not. And I think that this misunderstanding is the biggest challenges that will happen when it comes to DAOs.
Thank you, Mariana. So both of you agree that it's a matter of, let's say, definition, making sure that we have clarity in terms of understanding the things that a DAO consists of. I mean, the roles and the responsibilities. Clarity, I think, is
Clarity definition, I hate it because if you try to just like ask everyone here to agree on a definition, you will never get anywhere.
Yeah.
So I don't like the fact that we try to think. I used to like write a lot like about what is the actually definition of DeFi, and then I realized that everyone was like giving different interpretations. You need to understand is what it does and how it can impact others in order to regulate it. Even louder, okay.
we're going to do our best. You wanted to something?
It's also about substance of it, because it's not just the structure, but also the substance, like traditional entities. We see the purpose, we see who are the shareholders, the directors, when it was created, and we see the basics.
That's what I mean with what, but
Yeah.
when you talk about substance, then if you are not a lawyer, you're going to get lost with what is substance. And also, every European country, like, not every, but like, there's different definitions of what substance is, like, where your managers are, where like your taxes are, like,
No, let's say
reported. So
substance in the dictionary, basic, non-legal understanding.
it's just like the basic, what do you
Exactly,
want
what
to
you
do?
put in the end.
Exactly.
Luca, you've already elaborated on various things that you have worked within the guide, but I assume that some of these aspects are definitely core issues for the ecosystem. What do you consider to be the most important, the most urgent issue to them?
Actually, we discussed in the guide. We discussed now to a limited extent because there are limited precedents, and of course, because we don't have individual opinions, we have to follow what already exists. And I have to say, based on that observation, there is an expression in some languages. I don't know how to say in English. In French, you will say, "Je suis complètement d'accord à moitié."
I'm completely,
In
like, I
agreement.
agree completely in the middle.
Yeah, halfway. I don't
We meet halfway. We meet halfway.
No, no, it's different.
I'm halfway to completely agree.
No, it's different. I fully agree with that, but then only half. Something like that. So anyway, what I'm trying to say is, yes, definitions are very important. But what we find when it's now being discussed is, first of all, it's all about money and liability. It's not about philosophy or, And in court, it is about money.
Yeah.
And then you have some decisions, especially from the US, where everyone is liable for whatever reason. And then you have one decision from France, which is quite recent, that says, no, there is no presumption. You have to prove actually all the elements. The fault, the causation, and So it's already another, and it's interesting because it points at the fact that there should be clarity on that. So defining roles, and then based on the roles, defining liability for each role, so that each entity is responsible for what they do and not for what they don't. The part where I disagree is, I think we should separate clearly the DAO as, I know this is controversial, but computer code then also fulfills the function of some organizational entity. Okay. But as a DAO, I mean, I appreciate that it could be profit, non-profit, it could be my gym club, or decide which trainer we should hire if I want to do more aerobic, more anaerobic. There's a lot of interesting discussions we could have there. But this is one thing that has to do with the DAO, and we need to have a definition of the DAO to distinguish a DAO from something else. For instance, from a persistent script, which is not a DAO. The DAO may have persistent scripts, but it's more complex than that. And then there is the use of the DAO to fulfill certain needs that already exist. So I can say I have a public company listed in the stock market. Instead of issuing shares, I will issue tokens, whatever you want to issue. And then instead of the shareholder meeting, I will use the DAO to put people together. And that will be, I don't know if this works or not. Maybe I just said something totally unacceptable. But all I want to say is simply that there, the laws applicable to public companies would apply. And then one has to see how the DAO may contribute to better achieve the goals that the law of public companies is setting, which is like having a minimum amount of shareholders, making sure that they can decide, in a free way and whatever. So I think the two things are separate. They're both extremely important, but the rules and especially the definition of the rules. And of course, if the DAO is a DAO that is non-profit, then a lot of regulation will not apply because it just doesn't apply because it's a simple thing. But if it is something complex and it's getting into a highly regulated environment, which could be, as I said, a commercial company, which could be whatever payments, whatever you want to think, I don't know, but something very regulated, then you have to use that. So that's where, for me, at least now, but since I'm new to this, I'm very happy to change my mind. Because, because life is made of changing minds.
But I don't think that I said something different because I actually said that the wrapper and the regulation that will apply later on are really depending on the substance or the activity that the DAO is developing, right? So I actually agree with you, and I think that I say it, if it was not understood like that, my fault. But it's actually like that, like it's depending of what the DAO is going to do, and what I'm saying is like we do not need to reinvent the wheel, and that clarity doesn't come with the legal wrapper. With the legal wrapper, I will know at the level of liability and maybe who is responsible, right? The clarity comes from having a white paper, a bylaws, or something that people can read and decide if they want to become members or not, what are the implications and what are the roles and how this is going to be defined, right? And I was like thinking actually on like the definition, and like again, like there's like 3 words on that. The first one for me is the most difficult one to define, like what is like decentralized, like that I don't even want to go into that discussion right now because it will be another panel. But autonomous means we have smart contracts. That's like, long story short, that is what it is. In order to have like that, what we also need to do is have like some certification and like audits of the smart contract to ensure that they work properly and they're not going to create any damage. An organization, well, again, there's like different understandings of organization, but here what we are talking is a collective of people that came together to do whatever.
So,
whatever is what is going to define the wrapper.
Autonomous is not autonomous because a persistent script is not autonomous.
That's what
It's
I wanted
automated.
to keep a long place and
So-
long story short, because that's another one.
Even the implementation of voting, we voted on, I don't know, a transfer that requires conversion, and then what is telling the team of people off-chain who will just something, and how do you
That's the rabbit hole that I was trying to not jump into. That's what I said, like, long story short. But indeed, if we go that deep, then we are not in any of those.
No,
But-
most of them don't match the definition at all.
Not
And when it indeed it said something else, it's already clarity. But for instance, you say the legal wrapper, which is a term I really hate, and the white paper is different.
how will you call it?
To me, the white paper is part of the legal wrapper, whatever the legal wrapper is, because the white paper may have some binding legal obligations. So it's
It really depends. Like, if you take like the understanding of white papers that are in ICRA, then maybe yes. But before the white papers were used actually into the blockchain ecosystem, like the original way that they were used is to provide information. They were not mandatory, but you were used to show people how your token behaves and what were the token economics and all of that for people to make a decision to just like get the token, right?
but all of that has legal consequences. Because
yes.
but it has always been.
Well,
because
yeah,
all
yeah,
statements
yeah,
have
yes,
legal
yeah.
consequences.
Because
So-
you could refer to it and say,
It
hey,
is
you stated
misleading and all of that. Yeah.
I would like just to add one word on a thing that we have not yet discussed, but it's very specific. From our very short legal analysis, I'm sure Mariana and Anne have done much more. There is one angle which is very relevant and create the actual friction in court, is because a DAO is not an entity, it cannot go bankrupt. And this creates a lot of problems because whatever it is, it goes bankrupt. So there is a famous case, which of course the name escapes me now because I'm jet lagged, where they had to do some off-chain entity and then have insolvency proceedings started in the PBI, and then that was recognized as an insolvency proceeding under Chapter 15 in the US as a foreign bankruptcy. Now, I don't want to go into the details of this, but it is in our paper, the description and the references. So this is a point that in the future discussion, hoping that there will be a future discussion, one has to bear in mind. But to give this organizational entity some form, because it's possible to declare bankrupt also informal entities, as long as they carry out commercial activities. But it does have to have a minimum of togetherness. I don't know how to describe it. So this is a specific legal issue that we have identified on top of the usual rules on liability, what goes wrong, what doesn't go wrong. And the problem with the real problem with insolvency in this field in general is that normally insolvency goes one way, but here, because there is so much fluctuation in the market, you have these proceedings that go back and forth from insolvency to being solvent and back. So it's really something that we haven't seen for, we have at least 2,000 years of insolvency. I'm not going to say we have to do like in Roman law where the debtor was killed and the parts of the body were given to the creditors.
Bankruptcy is actually bankruptcy is considered kind of a crime in Germany. So you still have jurisdictions that are really strict on that. But what I think that this will apply to the cases that there's no a legal form around the DAO, right? Because if there is a legal form around the DAO, then you actually have normal procedures to go up to bankruptcy, right? Because there is a registration, you know where they are, you know what are the members, all of this. So that's it. On the study that I did about DAOs sorry, that was the title, with wrapper and without legal wrapper, what actually looked is that most of the DAOs do have a legal registration because not because they want to, but because it's the easiest way to protect the liability of the members. And what I was talking about the white papers that there were not legal consequences, I was not meaning to the ones that wrote the white paper, but if we consider that token holders can be shareholders, we don't just actually keep shareholders accountable in the same way that we have managing directors when something goes south in normal companies, right? So why a token holder, just because of the fact that they actually acquire these tokens, will have that level of responsibility. So the way that these projects are trying to just solve these issues is actually with legal forms that will limit it in any certain, in any point in time, the liability of those that have a role of representation of the DAO.
Yeah, I mean, all company law is about recharacterization of the legal form. Because you can choose what you want, but if it doesn't meet, it doesn't meet.
Stop you there because I want to add something, and then we will discuss legal wrappers.
But actually, we can jump on the legal wrapper and then one contribute afterwards. But I hate it too because it means something different. People are selling legal wrappers saying we're gonna provide legal certainty, we will shield you from liability. And once you dig into the actual entity type, depending on which wrapper it picked, whether it's Marshall Islands, a foundation, the Cayman, you realize that some of these setups, well, they haven't actually wrapped the DAO.
But that's not a wrapper, that's the jurisdiction, which is also different.
Yes, but they all refer to it, we are getting a wrapper, and then you see what they actually got, and it's an execution arm that takes in liability, and there are nuances.
You're talking about Marshall Island DAO.
Marshall, but also Cayman foundations, let's take I'll take the Swiss example, because we do the work in Switzerland. An association can be set up in 3 different ways. Either you put the DAO in it, or the DAO remains outside and just gives some indications. You have so many different setups. And people say, let's get a wrapper. What kind? What exactly will it do? What is it wrapping? What is the connection between the actual organization and the entity? So we kind of need to distinguish organization. We can tomorrow decide that we are an organization managing a box of chocolates. I love this example. This is a box of chocolate, we manage it together, we decide who can eat the chocolate, who needs to refill the box, whatever. we don't have a wrapper yet. And then we have the wrapper. And then the question is, who is part of that wrapper? Is the chocolate in the wrapper? Who is the director? And like, what are the connections? Like, it's two different things. There's like the structure and the actual community. So that's one thing. The second was like, for DAOs, I think we kind of need to take a step back sometimes and think, what are we trying to achieve here? Are we adding this DAO topic into whatever we're doing because there's a benefit to decentralization? Because we need the benefits of automation, the benefit of both? Like, why are we doing this? And in many cases, it's like, because it's trending, because we want us to, I mean, there's some good cases where it's like, we want to involve more stakeholders for like token voting. This is great, that's fine. But like, we need to answer that basic question, why are we getting the headache? Because we mentioned a lot, we mentioned like all the problems of insolvency, wrappers, like there's a lot of things that are not clear yet with DAOs. And why are we adding this?
But
Why aren't we just...
don't you think that wrappers in certain cases give some sort of operational clarity?
They give
Because
some
I think
good...
that's the point of having actually the wrappers, and I think that
No, I think the point is liability. Like
It's
100%.
clarity on paper, but many people don't even understand their own wrapper. Like, I mean, also depends who you ask. Do you ask the committee that was delegated by the organization to handle the wrapper, or do you ask a random member? Because I bet if we ask a random person,
Yeah.
okay, you heard of the DAO, and then you ask, is there a wrapper, first of all? Like, where do you find information in many cases? There was a vote, okay, then I want to know what's actively implemented. Because in some cases, you see the vote, great, and then what's next? Some projects have like everything published, but also how do I know it's the right version?
You know what, but it's not even that. Like, I just remember that was one of my questions on the survey that I did to DAOs. And I always think liability because, of course, I'm a lawyer and I'm always like scared about those things. But no, actually, what they said that was the biggest reason for them to just like go into a legal form around them. It was not even like the liabilities, but the fact that they could not contract or get money paid to them because there was no entity.
You can't
So this
enforce
is
them.
actually like an operational point of view that they have, and a real challenge that they have when they do not have legal entity.
Which is another way of looking. I mean, the insolvency problem is another side of it. But you see, I fully agree with what you said without half. I fully agree 100% with what you said.
Which
But-
hope you do not.
But no, I totally agree. I would like to add the fact that people have the illusion of having this wrapper does not mean that they have it. And it's also different when it is between private people and when insolvency comes in. Because when insolvency comes in, I would say especially in civil law jurisdictions, but not only, the judge may reclassify everything, find everyone jointly and severally liable, go for the assets where they are, and then you can look at your wrapper and say, so far so good. Especially if we talk about conservative jurisdictions, you know, and you go there and you say, hey, but I have a legal wrapper in the Marshall Islands. And the reaction of the public authority is not always benevolent. Actually, it can be the opposite.
But who will they go after? That's the question.
They always go after the money, so I mean,
Yeah, but in
they
terms
go
of
after-
members, when we say like this idea, let's say it's a simple partnership because there was nothing. There's the question of how do you identify members? You can identify a couple of them, but what about the others?
There is a problem of
Someone's-
yeah, I mean, there are a lot of practical problems. There are a lot of solutions. That's why we should define roles and have a uniform approach to this. Because otherwise, the illusion of having something, you know, like Mariana is totally right. White paper in the beginning maybe was written in good faith, but each statement may come with liability. And people may have made statements without thinking of the liability. But for someone else, this is, you know, something that creates an expectation. And if there is an expectation which is not met, there could be a liability. There could be, I'm not saying there will be, but that opens the door to a Pandora's box of issues.
And I think that like you just like touched on like another layer of complexity that is actually like if the jurisdiction of the legal entity will actually be accepted from other jurisdictions that want to claim ownership over that activity, right? Because I think that this is another misconception of the industry, and is that we think that we can go to any place and create a company there, and therefore we operate from there. And that comes up again the question of the substance. Like, if I live in Germany, I pay my taxes in Germany, why my legal entity is in Estonia? To don't put it so far away in the Caribbean. But like the German authorities will actually do not see those actions as a company in Estonia, but as a company in Germany. And this is really risky because the level of liability is not going to be of the one of the entity that I registered that I actually like registered also in Germany. It's going to be a normal partnership. And then the liability is going to be higher than an LLC.
But that's interesting. The liability question is the one that comes up all the time, and then the question becomes, who are we trying to attract? It's the same as, let's take just one sector where we have DAOs, this DeFi, and West France, and we have DAOs in many sectors with effects. It's like, do we want to create an ecosystem where just people, we add plenty of disclaimers, and people realize that they enter at their own risk and they are responsible for their actions and whatever they do and this kind of things? Or do we create something that's more comfortable ground, where people feel shielded from liability, they know what to expect?
This feels weird to be so loud all of a sudden. But basically, who are we trying to attract? Because we could keep DAOs the way they are and say that there's like some vagueness there because it's still experimental, it's like kind of a sandbox. I mean, often DAOs are figuring out things as well as they go, so you want to have flexibility. Okay, we keep it that way. It's an experimental place, you enter at your own risks. And that's it. That's one option. Other option is, okay, wearing all these things, protecting, adding shields, but it adds complexity. It also makes like this experimentation more complicated. Like when you look at some of the super easy wrappers to set up, they get forgotten at the end because probably the project died and then you're like, oh damn, I created this administrative burden and now I need to dissolve and everything. But for like some other DAOs, create the duration of some of these DAOs is like, they just die so out so fast because the community never picks up or like the pressure it never goes further. So you also want to have this possibility of just having a group of people who test something, and if it dies out it just like dissolves, and they accept kind of this option of having more responsibility and more exposure during the first phase. Also just because there's less assets at stake, there's less people. Maybe you're just in testnet phase. Like, instead of just talking money and like liquidations, just regulatory also issues. It's always the same thing. Like once you offer a mainnet version of your product, there's money at stake, so there are users involved. You don't want to mislead them and so on. If you're just doing a testnet version where nothing can be lost, well, I'd say that the exposure is smaller.
But why would you even need a DAO with that product? Like, I mean, like your example of the like your example of the guys still like only more I imagine like crypto foundations are thinking, and here there is a podcast, so you know in Europe at least like how that regulation goes. So it's not just like right like they can like simply understand looking at there is financial gain. But if it's testnet, why do we even need it out there? And I think that like it goes back to what Luca was saying at the beginning, is like, do we really need it out to solve something that we have not been able to solve with like a normal organization or not? Because otherwise what we are doing is just like following the tendencies and the scene, right?
Just to look legal, it's a pity because this microphone is limiting the ability to talk on each other. But it was better without innovation. But
This is very interesting in the crypto conference as a statement.
I can do much
It's coming
worse.
from the UN.
I can do much worse. But just because this is a legal discussion, I would like to say we have to separate, however, conceptually, and I think there's too much attention maybe now, the DAOs from any tokens which is an asset in the DAO.
Yeah.
Because very often we a monster because the traditional tools of private international law don't work because they have territorial reference which does not apply. So there are things like that we really don't know how to deal with. But since we have here also to refer to possible solutions, there is a organization which has the same similar mandate as our organization, which is called the Hague Conference on Private International Law, which is working on private international law aspects of tokens. So if people are interested, they can go and look at what we are thinking there, and there is a deep discussion. I don't want to get into that discussion. I just want to say the DAO as an entity is separate from its tokenized assets.
You don't want to dive into that discussion, but actually there's one point that's super relevant about private international law is that DAOs, transnational, people from all around the world, don't necessarily define which law is applicable to their relations. How do we solve conflicts? Because this is one of the things every organization will have conflicts. And in that case, one of the things that's overlooked, we don't agree. We are not okay with how the vote went. We don't agree with the fact that someone claimed to represent the organization on-chain. How do you solve that? Like even DAOs giving out grants. There's no agreement, that's like a proposal. So if someone doesn't deliver on a service agreement or doesn't respect the conditions of the grant, lied on the application, what do we do? So it's like part of this whole debate of what are the advantages of adding this layer, what are we trying to achieve versus the practicalities that don't make it so easy.
That was actually like what I have like the. If you're interested in that, like there's a paper I wrote on that, which also proposes samples at the end. But it says that basically we need like a virus or white paper, whatever document, and that's one of the things that you need. You need what is the DAO going to do, the roles of the people that will participate, and among them who has like representation of the DAO externally, how you solve issues within the DAO and make decisions. And the other one was actually who is auditing the smart contracts and who is building the smart contracts. So, and that's another one about taxation, but you have like 2 hours next in taxation, so I will go with that one. But all of these things need to be defined in that document or website, or whatever you do, for people to decide they want to engage and have like the clear games, the rules of the game defined before engaging. And I think that it goes back to, again, look at the setting, and it's just like, is this bringing any value? Because if it's not bringing value, like it's absolutely worthless to just trying to implement DAOs there. One thing that I must say that is really interesting when it comes to like how we make decisions and how we solve it is when you have like actually on-chain voting systems, because you can also like track back and understand like. Especially, I think for like budget allocation, like that's really interesting because we can see how the decisions were made and into what was allocated and for what. So there's like total transparency in like budget distribution or resource distribution is actually well done. It's like this is not like the magic panacea that it will work regardless. But if the rule here, it actually like brings a lot of transparency in resource allocation. And in those cases, I think that there is a lot of value for the DAOs.
I agree. It's like despite all this, I mean, as a lawyer, you always feel the issues because people reach out to you with the issues, or they reach out with you how to prevent those issues. So basically, your brain is there to scan for all the red flags, and there's a lot of them in DAOs. But there's one thing that's quite positive, and probably is like the reason why so many projects like go for it, if they really comply with the ethos, is you can make sure that you have a product that will not change if users really don't want that. Because like you have sometimes like those codes like we want to, I don't know, we're gonna deploy or not in a new chain, we're gonna shift this, we're gonna close this market, we're gonna do that. Well, how many products in, let's say, outside that ecosystem you have where you're gonna say, hey guys, I don't want that. Like otherwise it's just gonna be a CEO decision, we're adding a new feature, we're doing this, we're doing that, and maybe everyone hates it. But you don't have a say in it. Here, if this kind of decisions and network updates, protocol updates in general are subject to a vote, we're actually asking you as a user, do you want this?
But on that, I need to play devil's advocate. I worked for a layer one. I worked for a layer one in the past, and I must say, like, engineers really hate that. Because you are asking people that has like an interest on the network, if you should update it or not, but you have an inside team of engineers that are living and breathing that technology. They work 24/7 on this, and now some Ramon Rico and say like, I think you need to update it. Like that, I don't think that that's like like I understand the point of the engineers here, like they actually it's good to engage the communities, but in like protocol happens and we say like that's one of the things that I always say you shouldn't do it.
Um, because we run out of time, I would like to give also the floor at the end to the people here discussing how to ask some questions. I just have one final question for you regarding the potential of having a global framework for those. Do you think that is something that would be effective? Do you think that having some sort of standardization, I mean, even looking at the ones that mentioned before, Mariana, like knowing specific things with regards to what the DAO does, who is responsible for what, what's the role of objectives. Do you think that such a global framework would work with specific elements that every single DAO would have followed in order to make sure that we have some sort of clarity?
I would say not now. I mean, if that is coming from like a regulatory perspective, I would say like no, it's too early. We need to see how they continue evolving. We discussed before, one of my proposals was actually like take advantage of the European Union because we already have like some level of alignment and do a sandbox where we can test the different, not a regulatory sandbox like the F0 like the security, but actually just like having DAOs working and operating in different countries across Europe to just like see how we collect the source learnings of what are like the actually like things that we should like try to unify when it comes to a DAO, which is I have my 5 points, but like everyone is entitled to have 5 difference, right? We only agree if we test, check, and give the opportunity to DAOs to showcase if they bring any value. But that's right now, I'm just like I will be scared that we will not only like limit the innovation, we're just simply killing it. Like as like I mean imagine if Nika we have like actually like for NFTs or DeFi, they would have killed the innovation on those two industry, like on those I don't know, industry things. So I think that like that would be exactly what would happen to us if we regulate right now.
I mostly agree with her, but I would say my first answer is yes. Not no. First of all, we need to have we cannot have a unanimity, but at least a majority consensus on terminology. Because now, everything is something or it's opposite to, depending, to so many people. So first of all, let's try. I'm not saying we have to have definitions cast in stone, but we can have working hypotheses and build towards, support for the working hypothesis. Secondly, I think that I find just the genius I told Mariana already. The idea, because in Australia we have also models which are working well, like the ones in electronic transfer records. But the idea to put something together and test it, and then go back to the drafting table and fine tune it. Except that because I come from the United Nations, it's very good to test it in the European Union, but let's test it also outside. Because otherwise, we have an imperative, which is if we cannot address the digital divide, at least let's try not to widen them.
Indeed.
And if we test only in the a limited part of the world, I'm not so sure. And there are countries in all the continents that are willing to test and to provide input. So maybe the funding for that could come from certain sources, but then we could have the testing, facial testing in different places with different economic and legal systems, and then get together. And then I would like again to say, if we have something like a model which is not binding, but can be used, and maybe with parts that can be fine-tuned based on contractual agreement, maybe we can go towards a solution that is really useful. But definitely no regulation, and definitely not too soon. So maybe this kind of roadmap which is at the same time is innovative, but it is also inclusive. And I think that inclusivity is what we really need in this field now.
Disclosure standards, yes. Other standards, no. Testing, not necessarily. Observation, yes. Because if we disclose more, let's let the industry test. I mean, some things that were good practice 1 year ago were no longer now. Something that works for one type of organization doesn't work for another. Depends on the sector. The things that don't work out, they just don't out. The SSC says that. And all we need to do is better understand through observation what worked out or not by actively testing. Because I think we're kind of over-engineering it. Let people test whatever they want and then see, oh, this worked out well. And what exactly worked out? And if we have some disclosure standards, we can better understand. It's like trying to dissect the DAO and basically see, okay, that was the good part. And then maybe in 2 years, we'll better understand what happens and we'll be able to develop some standards on like other things. But for now, I think it's, despite the years, because DAOs is not like a new thing, by the way, it's been a couple of years, right? It's still too early. We just need to understand what actually is happening there.
But like, there's no better way to learn about things that are related to your hands on them, right? Like,
But you observe what people do.
yeah,
Like you don't over.
maybe there are different ways to learn it, like that goes against diversity and like different perspectives. But I think that like the fact that, and this is my last comment, but that is important.
But it's never
If
that.
the regulator or like the one that's like trying to regulate DAOs do not understand how it works because has experimented with them, the regulator is something that they just observe. And I think that observe is like always an external perspective. And when you actually experiment with it, you will understand what are the challenges and what are the things that you actually then need to address and where the risks are, what is like the regulatory need for actually going there, right? I will stop there.
But it's observation for infiltration. You infiltrate and you observe actively so that you don't position yourself like, okay, what does this thing? You actually go down there and stare what's happening.
The UN is already experimented. The IGF actually like is trying to develop the working groups as DAOs.
I think we should get back to the pro to the moderator because she's a social
We're
scientist.
taking over.
She's a social scientist and she knows about the discussion between should the observer be inside or outside. It's a classical social.
Well, I'm social scientist from a political perspective, so I'm a political scientist, so I will have to respond politically. I would like to say it from my own view. I like to test and monitor at the same time because I think that this gives you a different perspective and allows you better understand and have more insights from the actual inside of the testing. So that would be my own perspective. But I would like to open the floor now to our audience and thank you for staying with us for this discussion. I think it was very interesting. I was very much informed about things. So anyone feel free to raise your hands and take the mic. Or drop mics.
So we were talking about DAOs and name only where you have one person, you go down and start. But what happens, and this happens quite often in our industry, when the attention leaves and the community is not voting? So you have potentially 800 members, but realistically you have 2 people voting. In a publicly listed company in the UK, for example, you can have a quorum of 2 and that's fine. It's not going to like turn the publicly listed company back into a limited partnership. With a DAO, will it?
It depends.
Yeah, it's like a resolution. So, what do you think of that?
I mean, it depends. I mean, I think that's something that we mentioned at the beginning, like, you need to have like roles, right? The fact that you do not have active members, that doesn't mean that you do not have members. And if you're a public listing company, like, I guess that there's activity happening there, even you don't have like your shareholders actively participating, right? So I think that it will really depend on the nature of the activities that DAO is conducting. But then it goes again, like, what happened? Like, do you dissolve it? The DAO?
I would
You
say
give it
it's just like the potential. Potentially, this could change, and then maybe there's a possibility of dissolving it, but maybe there's 2% now, maybe in 2 months it will pick up again. It's like it's the same for companies. Maybe all the shareholders are super passive because they don't care, but someday there'll be one decision that they really care about, and everyone will hold on a sudden. It doesn't change the nature of the entity.
But the question is if this is important for pursuing the function of the DAO. This is one of the things that actually can be automated. Like if you don't have members active, and number of members active for a period of time, the thing dissolves itself and goodbye. So it is something that to some extent you can leave it to the party alone.
What would buy? What happens like if there is assets?
You leave with the
Who lives with them? Like the
like,
members?
I mean, if there is a market, you liquidate them on the market. You can release them and have an automated liquidation.
And what happens if like after that, like one of the members comes and say like, I was part of this DAO and then I was on holidays.
They read your friend's white paper and they know what's going on.
So DAO forever. What they did is that if the DAO is like inactive for like a couple of months, whatever inactive means, like no votes at all, whatever, then the board of the wrapper was becoming the one in charge of everything.
Okay, but that's pre-established. Like
Yeah, that was
That's
pre-established.
what-
It was put in like the bylaws of the actual like entity that was supposed to act as
Yeah.
wrapper. But it was super interesting because then the question was like, what does it mean inactive?
There's always a question.
Yeah, like it's just like
Like,
no
that
votes,
must be so much fun. You actually like liquidate
It's
everything that
great.
you to combine, like bring them to court, and like just has never seen the word DAO. Try to define what happened. What is this thing again? Like someone does that, I want to be there.
I think
No, someone uses dino. I do one only in the past, like,
Oh,
are we talking about dinosaurs?
Inactivity normally is defined, even in the smart contract.
It's like, but we are coming to a like level of maturity that I don't think that we have in the industry. Like that's how like grown-ups will act, and they're not there yet.
Do you think the final notice, the industry does not deserve the lawyers?
It's very often more
But do you want to do the works?
No, I think the industry doesn't deserve the lawyers. She said the level of maturity in the industry is not very good.
No, the lawyers are having fun.
The industry is not mature. Like DeFi is also like not mature. Like the crypto industry is like getting there, but it's still in this infancy. Like I don't think that like we have seen like everything that can do. Yeah,
We reached
yeah,
teenagers.
teenagers are worse soon. Yeah. I mean, I don't think that like we are at the level that everyone understands everything to the point that we actually like have that on a bio of an app. So
Any other questions? Okay, so yeah, please.
this is what happened when you put 3 lawyers in the same.
So, do you think that like the current legal legislation, like in the EU, for example, is sufficient for DAOs, or do we need something like in Wyoming or Idaho, these special DAO laws that treat DAO as a legal entity?
The question is, do you refer to having someone a law that recognizes DAOs without any wrapper, however we define it, just like for them being those holding organizations? Or, well, this could be useful to have some clarity on that actually. What do we do with the floating things? Because I mean, most of the time when we refer to DAO regulation, it's mostly about creating a new wrapper. Like all the DAO laws were wrapper laws in the end. And I don't think we need more of that. It's more about probably like acknowledging what happens to an entity that has like incorporated and has like that would be pretty useful.
Of course, from the United Nations perspective, we don't criticize that. To the fullest extent. From a personal perspective, and mindful that I don't have the experience of that. But my impression is that more guidance would be useful, but not along the lines you mentioned. I think that, to me, and I am aware that we talk with a new set of considerations, but a lot of the legislation we have seen so far is driven by technical considerations and not by legal considerations. So what I read is not how I would draft it. Even the famous with DLT I had endless discussions because it's a DLT Act that says this is not about DLT. Already the starting point is a bit what it is. So,
saying what it says.
so it's, yes, for guidance, but for us, the idea is always to be technology neutral and to drive in terms, more or less ready to be future.
I love building a sense of strategy because we know that doesn't exist, even when it comes to technology. We can have an argument on that as well. But I think that I already answered your question before, and I said that maybe regulation will come at some point. What we have seen right now on at least on the study that I did, where I did different comparisons, you have two kind of tendencies. One that is just call it the DAO regulation, but basically what they're doing is adapting one of the legal forms that they have at the national level in them doing it for the DAOs. So it's a great example. They took associations and the other one is associations and foundations. Then you have others that are the kind of approach, Marshall, the area called what's in by. They create a new jurisdiction. I don't remember which one was. I think I'm remembering it. Yeah. But what I think that we should do is just try to define what are the things that are DAOs needs to understand. We have mentioned it many times. What is it that they're doing? What are the roles? How you solve conflict? Which are different things that I know is convenient. That was the one that you looked at actually. And then you let them play around and see how that works. And with the lessons that you see for observing or interacting with the DAOs and deploying them, then you actually can try to spread. I would say go for a regulation because if people do a directive, we know what happened. Every member say will do whatever they want with interpretation. But I don't think that we are at the point yet on the maturity of what they understand for the DAOs and the DAOs that have been deployed yet to go into regulation.
Okay, I assume we are already beyond our time. So thank you very much for joining us. Thank you to our panelists for the wonderful insights and have a lovely continuation of the day.
Oh, that's it's that's my
There where it was not so soon, this is by one hospital. Yeah.
I don't know. Yeah, no, the question is. Yeah, right? So let's go and start.
Just the same order as yeah. No, all the speeches should 15 minutes. Let's keep it this way and everybody let us
Yeah.
but let's see headlines of and then all the presentations are here, and you show me how it's